All right. Hi, everybody. We are officially live on our webinar. Welcome to Solo Suits Weekly Webinar. We hold these webinars every Wednesday with the goal of helping people learn more about how to navigate the debt collection process and increase their chances of settling debt with debt collectors and debt collection law firms. Today, we are super duper excited because we have a special guest joining us. We have Sibley Ortiz, who is a former collections executive, joining, and she is going to share some tips and tricks and insider information about her experience working as a collections executive. And we're really excited to learn from her and her experience. And yeah, I hope that everyone is having a great day.
Your father knows about saving money. Everything I'm wearing.
Sorry about that. We had a couple technical difficulties, but I hope everyone's having a great day. If you're watching, please go ahead and submit your questions on the chat. We want to hear from you and get around to your questions and answer your questions. But with that, I wanted to give Sibley some time to introduce herself. Sibley, can you tell us a little bit about who you are, your experience in the debt collection industry, and what you're up to these days?
Yeah, hi, I'm Sibley. So I've been in the industry for almost 10 years, started pretty young, came in because they needed a Spanish speaker. So it was kind of my way in. So came in, helped out, was a legal assistant / collector, then moved up, and my last position was division head. And currently I am doing some consulting work.
Perfect. So can you tell us a little bit more about like what your specific role was as the debt collection head? It was for Suttell Hammer, right? A debt collection law firm?
Yes. So what I did was I managed our collectors. So, just anything to do with them specifically. So did some escalated calls, answered any questions anybody might have had, and just made sure everything ran smoothly as possible.
Very cool. And now you're working in consulting. What specifically do you do with consulting?
Financial consulting. So really stuck with me. So finance is kind of where I like to be.
Awesome. Well, we're really excited, Sibley, to have you and to learn from you and your expertise in this field. I have a few preliminary questions before we open up the floor to all of our viewers. So with that, I'll just go ahead and jump right into some of these questions. We wanted to kind of pick your brain and get an inside look into the debt collector's world. So first question that we have for you is, what happens if you do not pay a debt collector?
So that really can vary. And one, I do want to start off with, I'm not an attorney. So just a heads up on everybody, right? Legal advice, not really something I can give, but in general, right? So there's different types of collections. Credit reporting is obviously something that everybody knows about. So that's something that most likely will happen. It depends. Some creditors choose not to report. It's going to be completely up to them and their policies. If it's in the legal aspect of it, you can get sued. Unfortunately, and then from there the lawsuit could proceed, so it could turn into a judgment, and then depending on your state it could go with other efforts such as a wage garnishment, a bank garnishment, potentially a lien on properties, but that's all going to depend again on your state and then what type of collections company you're talking or working with.
Yeah, so it sounds like there's all sorts of things that can happen if you don't pay a collector. Worst case scenario, you get sued and then your wages get garnished. So it's really important, to make sure that you're proactive in responding to debt collectors when they reach out to you. I think the worst thing that you can do is probably ignore them, because not only is it bad for you, but it's also bad for the collection agency. It just makes the whole process harder for both parties. So be proactive, respond. The next question we have, Sibley, is what is a debt collector's number one goal? Would they rather, take you to court and sue you, or would they rather try to settle the case outside of court? What does that look like?
For the most part, generally, I would say like you were saying earlier, communication is huge, right? So ignoring it is not really going to make it go away. So, and I know it's a difficult situation when anybody owes money because no one wants to be in that situation. And as collectors, they know that as well. So they're not here to make the situation worse. In reality, they're there to find a solution that works for everybody. And ideally, it's going to be to repay that back in full, but in something that's reasonable for you and reasonable for whoever it is they're collecting for. So, if it's going to be something in 2 payments, if that's reasonable for you, great for them. Obviously something in like 20 years, obviously might not work. It's not going to be very feasible for them either, but just finding something in the middle where it's reasonable for you and it's a good time frame for them as well.
Gotcha. And would you, kind of going a little further with that, would you say that like if a case has gone to litigation already, the collector has sued the consumer for the debt, would you say that they would still rather stay out of court and try to settle it outside of the legal process? Or I don't know if you have anything, like any thoughts on that topic. Like, would they rather try to settle even after suit has been filed outside of court, or would they rather go through the whole process?
So just to clarify, the collector themselves wouldn't be the one suing, it'd be the firm. So just technicality, sorry, just want to throw that out there. But then two, for the most part, I'm going to say is that, yes, one, if they don't have to incur costs to file and serve you, that's ideal for everybody. So pre-litigation is always the way to go, right? So after they do file a lawsuit, you still want to communicate with them and try to get something set up. There may be specific counties or specific judges that say, hey, like, I'm going to require you to still show up just to tell me that you came to an agreement or to show me a written agreement. But that's really going to vary on the county and the judge that are more on the particular side. But for the most part, the courts don't want to deal with either of this either. So everybody's happy if you can get that something set up prior to that court date.
Gotcha. Okay, cool. Well, can you tell us what debt collectors typically think about debt validation letters and other like legal tools? And when is a good time for consumers to use such tools like a debt validation letter?
I'm not entirely sure if there's really any feeling about it, to be completely honest, because if you're wanting specific information, go ahead and ask. It's really up to you. If you legitimately think something may not be yours or something may not be correct, you're encouraged to speak up. Right? I can tell you that they most likely do not want to be suing on something that may be incorrect, but if you're not bringing it up to their attention, how is anybody going to know, right? Things can happen. So definitely, if you're going to bring something up, go ahead and do it. It's your right. No problem with it. And I don't think there's any particular feelings about using certain tools, as long as those tools are actually helpful and useful. There's certain tools out there, so you want to do your research. There's some tools out there that may actually make it more difficult for you, or that may even suggest you don't communicate with them. So just do your research that you're using something that's good would be my advice. But I don't think there's any particular feelings about validations or anything in that aspect.
Yeah, I think just to kind of clarify too, it seems like if you're a consumer and you're trying to verify that your debt is actually owed and it's a legit debt, it's not a fraudulent debt, collectors want to work with you. They're not just trying to collect on fraudulent debts. That's not their goal. They're trying to collect on real debts from, that you actually would owe. So I think that it's important to, you can use those tools to your advantage, but just know that collectors aren't always the bad guys. Like they do want to work with you to resolve your debt issues, and they are willing to do that. So yes, let's see. Next question I had for you, Sibley, is we want to talk a little bit more about like how to resolve a debt collection case. In your experience, how much would you say that a debt collector or a debt collector or a creditor would typically settle for?
That is honestly such a broad question, and it's going to vary on a number of things, right? Everybody's internal policies and procedures are going to vary a lot. So that's one right there is huge. Every bank and every creditor and every lender, everybody's different, right? So you can't compare oranges and apples because everybody is very different, also depending on what type of loan versus like a personal business credit card, everything's different. So you want to make sure that you don't compare, again, apples to oranges, completely different. And then again, I don't want to sound redundant, but for the most part, your situation does play a factor into it. So if you call in and explain to somebody on the phone, like, hey, unfortunately, I had a stroke, for example, I can no longer work, I'm on a fixed income or anything like that, and explain your situation, it can help, or it can be taken into consideration as well. So just keep that in mind, that again, communication is key. So maybe right now you can't do anything, but you're like, hey, I'm expecting some money in the next 2-3 months because I'm going to get this huge deal going on. Can we do something smaller in the meantime? Something along those lines. Just definitely, again, just call, have that communication line, and explain the situation and see what can be done, because it's going to vary case by case. And again, creditor and lenders, they're all same thing, but they're all internally very different.
Okay, so it really depends on many factors, like who it is that's suing you, the creditor or the debt collection agency. It also depends on the type of debt you said involved, whether it's a loan or a credit card debt, maybe a medical debt, et cetera, et cetera. So there's a lot of factors that will play into how much a collection agency or creditor will accept to settle a debt. And I do think I want to emphasize that oftentimes one of the biggest factors is your current financial situation. If you are experiencing hardship, they may be more willing to work with you. But keep in mind that a lot of creditors already have access to your financial information. So it's important not to lie to them and say like, oh, I really can't afford to pay my bills, when maybe you can. Because they may already know some information about your income, and they're not going to want to accept a less or a smaller settlement if they know that you can afford to pay more. So keep that in mind. It's good to be honest, and as Sibley said, communicate. Let's see, other questions. So you already kind of touched a little bit on this, but I wanted to see if you had any other thoughts on settling with original creditors versus debt buyers. So like in the debt collection industry, you've got original creditors like banks, financial institutions that issue credit. And then you've got organizations and companies that purchase debt portfolios in bulk after debts have been charged off at the banks, and they collect on these portfolios, right? So you've got debt buyers, creditors. Do you feel like there's a difference in the amount that these two parties would be willing to settle for? Like, do creditors require that you settle for more versus debt buyers, or what are your thoughts on that?
I've seen them both on the extreme ends, to be honest. So again, it's going to vary on their internal policies. Some of them are just like, hey, just take less and get it out the door, and some don't. So it's really going to depend. And I've seen it both on original and debt buyers. So it varies.
Okay, so it sounds like it varies. In my experience talking with attorneys, I would say that they often talk about how debt buyers may be willing to accept smaller percentages because they often purchase these portfolios in bulk at a percentage of the original debt amount. So they're buying it for like pennies on the dollar, and they may be willing to accept a smaller settlement because even if they do settle for less, they're still likely going to make a profit. That's just from my experience talking to attorneys and people in this industry too. So I just wanted to add that as well. Next question is, how can I increase my chances of settling my debt? Do you have any thoughts on that?
Have all the information that they may ask from you. It just saves everybody time. So if they're going to ask you for income versus expenses, have that handy. Some people don't. They're like, I have no idea. My wife pays all the bills. I don't know what we pay for our car payment. So having that information with you is going to be very helpful, and willing to give that information as well, because it's very hard for someone to try and negotiate a deal when they don't have the full picture of what's going on. So I think having all that information that they may ask from you is gonna help you a lot.
What is some of the information that they may ask a consumer to share?
Again, it's going to vary, but generally just anything that's going to paint a good picture of where you're coming from, right? So if someone's making $10,000 a month and their expenses are only $2,000, like, hey, there is a big gap right there. What's going on? Why couldn't you just maybe pay a little longer and get this paid off in full, back to what's fully owed? So that, just anyone's going to paint a good picture. But again, being truthful, right? So that, again, if you're like, yeah, I am making $20,000 a month, but I have a family member with serious medical condition and 15 of that's going towards them and keeping them alive. You're like, oh, okay, that paints a very good picture of where someone's coming from. So again, just having any information that's going to help them see where you're coming from, it helps a lot.
Awesome. Yeah, I just think reiterating, be honest, be truthful, be forthcoming, and you'll probably increase your chances of settling the debt. Here's another question. This one's interesting. How do I negotiate with debt collectors? Are there certain things you can say or do that will help you with the negotiating?
I think just make that known that that's what you would like to do. It may not be an option. Maybe some creditors don't settle at all. Maybe if it's past a certain point of litigation, maybe you have an active garnishment. So maybe at that point it's not a possibility because it's gotten to the point where they're like, hey, we'll accept the full amount. So I'm sorry, I lost my train of thought. What was your original question?
Yeah, the question was just like, how do you negotiate with debt collectors?
Right. So definitely just have it be known. So if you're going to call in and be like, hey, this is me, go through all your authentication stuff, and then just say, hey, I understand I may owe X amount. I get that, but unfortunately, I don't have that amount. Is there options for me? Can you walk me through it? So that would be the best way, would be my advice.
Awesome. Great. Do you have any tips so Sibley's not an attorney, I'm not an attorney, we can't give legal advice, just provide legal information. But Sibley, do you have any tips for people who've been sued on how they can prepare for court?
One, know your dates. Know your dates and times. You'd be very surprised how many people call us, or they call and just say, hey, I missed it, I didn't know, or something like that. So that'd be my biggest thing. Is just be aware of when you have something coming up. My advice would be maybe to read if it tells you to bring something or to file something, or again, I didn't do too much with the courts themselves, so I'm not entirely sure on that aspect. But that would be just my advice in general. Read anything that they may tell you to bring, and then just know what date, what room, what all of that, because you'd be surprised how much that happens when people don't know that beforehand and then show up and then maybe miss their hearing.
Yeah, that's really good advice. And typically that information will be detailed in the court documents that you receive, which are called the summons and complaint. In some states, the complaint is called a petition, but typically they're known as the summons and complaint. So typically your court information, and if you have any trial information, it will be outlined in those documents. Sometimes lawsuits will get filed and the trial or hearing date isn't scheduled until afterwards, but you should receive a notification from the court telling you when your hearing or trial is scheduled. So I do think that's great advice. Make sure that you prepare ahead of time, maybe call the court clerk, ask them where to go, make sure that you know exactly where you're going when you get to the court so that you aren't late and you don't accidentally miss anything. Because failure to show up is basically considered usually admitting that you owe the debt, and that you don't care to settle it. So it's really important to show up. Don't ignore debt collectors. Don't ignore the suit. Be proactive and take action. Let's see. Next question is, let's see. What should I do after I've been sued with a lawsuit?
If you're in a position to come to an agreement, definitely I would suggest that being one of your first steps. Again, I can't advise whether you should file an answer or response or not, legal advice. But if, for example, if you have the funds to pay it off, paying it off gets rid of it. And then you don't ever have to deal with it again. So that's definitely, if that's a possibility, but I understand most people, you're in it because you can't, right? So completely understand that. So my personal advice would be to give a call and to set up an agreement, because maybe you can't pay it off in full, but I think most people have a very bad misrepresentation of what that conversation is going to be like, when in reality you can just call in and you can realize that you can set up a very affordable arrangement and, you know, not have to worry about it and just make your payments, and then next thing you know, you've paid it off and you're done.
Yeah, I mean, I think that's obviously the ideal outcome would be that you reach out, negotiate, and then start making your payments. But if for whatever reason you feel like you actually have a defense in the case, and you feel like, you know, maybe the debt amount is incorrect, or the statute of limitations has expired, or if you feel like there's just some reason that you shouldn't have to pay the debt, it's also really a good move to draft and file an answer into the case. I'm going to go ahead and drop a link to our website where you can do that. I just put it in the chat. So yeah, if you've been sued, consider filing an answer. Sometimes filing an answer can also buy you some time to negotiate the settlement without running the risk of entering default judgment. So those are just some things to keep in mind. Next question is it too far gone to settle my case if my court date is tomorrow?
So again, every county may be a little different. So the judge may still say, I still want you to appear and let me know in person that something has been reached. But I would say go for it, because the likelihood is that they probably don't want to go to court either if they don't have to, because you come to an agreement. So just, yeah, reach out, give it a shot. Worst case scenario, it's like, hey, too last minute, can't do it. Best case scenario is you come to an agreement. If they're able to take it off the calendar, great. No one has to go to court. If they're not, you can at least just go in, already know that all you're going to do is let them know you have an agreement. And then that's, and, you know, other details that may pop up. But for the most part, I would say, no, just give it a shot. Give them a call, see if you can come to an agreement, even if it's last minute.
And if someone's been sued, who are they supposed to call to negotiate that?
I would look at the summons and complaint or the petition, and it'll tell you who's the one that is doing the suing, and then all their information should be on there. Your case number, if there's an internal reference number, it most likely will be on there, and then and maybe an email, all their contact information will be on the petition or the summons and complaint.
Awesome. Well, great. We've spent some good time going over some basics. And Sibley, thank you for your insights. Before we jump into the questions from our viewers, I did want to just ask you one more thing about the difference between legal collections and regular debt collections. Can you speak to that at all?
I didn't do very much, or I didn't do regular collections, so I don't know the ins and outs very well, but I'm assuming the big difference would be that they don't sue you. Would be the biggest difference that I could imagine being. Other than that, I don't know much more details about them, since that wasn't my area.
So you were in legal collections. So just to clarify, like with the legal collections, that means that you work for like a debt collection law firm. And you're not an attorney necessarily, but you're still working to try to collect debts even after they've been filed suit. Is that right?
Yes, or that was, yes.
Okay, so that's I guess what we mean by legal collections, and regular collections would be before a lawsuit has been filed. So maybe just a regular debt collection agency, not a debt law firm, and it has workers that call people to try to collect the debts before legal action has been taken, I think would be the difference there, right?
Yeah, my guess is they'll probably call you a lot more than the law firms will too. Would be just a general guess. I don't know their exact methods, but I think that's a probably good guess as well.
Oh, okay, interesting. Do you say that just because you didn't do a lot of outbound calls during your time working in a debt collection law firm?
I say that because they have less methods to work with. So I'm assuming that they're the ones that, you know, really have whatever methods they're given, they probably try to exhaust them as much as possible, because they don't have that driving force of a lawsuit, would be just my guess. Okay,
interesting. Cool. Well, I think we'll just go ahead and jump into the questions on the chat for now. And yeah, if you're watching, please go ahead and submit your questions. We want to get to them. The first question is from Regina. She says, I have a 5-year-old debt with LVNV Funding and Portfolio Recovery Associates. Realistically, what percentage should I settle at? I want it off my credit report. Any thoughts on that?
I don't know exactly what they would do. I would just give them a call and see if they're willing to give you their number and just have a conversation about it. If they're like, hey, I can't do this percent that you're giving me, then let them know you can do a payment plan, or just try to meet in the middle somehow. But I don't know what they would do because, again, it's going to vary, right? I don't know if it's in a lawsuit, if it's in-house. I don't know the financial situation of yours, if you have like extreme situation or not. I'm not entirely sure because I'm assuming it's all going to be a factor. So that would be just my best advice.
Okay, yeah. And, I have a thing to say about this too. LVNV Funding and Portfolio Recovery Associates, they are debt buyers. So they purchase portfolios from financial institutions and then try to collect on them. And then sometimes they will sue. So since they purchase the debt, they may be willing to accept a lower settlement. Not always. Like Sibley said, there's so many factors that play into it. But just be aware that when you're dealing with LVNV Funding and portfolio, you might be able to settle for less than if you're dealing with just the regular creditor or the original creditor. Let's see. The next question is from Kizzy Corner. It says, I received a motions for summary judgment stating that the plaintiff won the case. The hearing is October 24th. Do I have any options for the hearing, and could I settle with the plaintiff beforehand?
On the legal part, I'm not sure to be, unfortunately, sorry. I don't know about that one. But you should still give them a call because at the end of the day, they still would love to set up an agreement with you. So yes, absolutely. I would suggest to give them a call.
Okay. Yeah, I think just reiterating again, be proactive, reach out. And the next question is from Anne. It says, I have 3 lawsuits from the same law firm for credit card debts. I tried to call in to settle, but they said they don't want to settle unless I give them personal financial information, my income and expenses. Is it safe to provide that to them, or should I ask to speak to one of their lawyers and negotiate with the lawyer instead of their operator?
My personal opinion would be it's easier to get a hold of one of the representatives than it is an attorney. So I would 100% suggest you speak to that representative. At the end of the day, it's secured information. It's not going to get shared. So I think it would actually be a lot easier for you in the long run because they're the ones that do that all day long versus an attorney that's, doing multiple things. So I think you're actually better, not better. I think you should definitely talk to one of the representatives.
Yeah, I think the representatives are there to kind of take some of the load off of the attorneys, right? And to help with with whatever the attorneys themselves would do. So I think to answer your question, Anne, it sounds like it is safe to give them your information if that's what they're asking for. And sharing your information, like your income and expenses, can actually get you a better settlement if they can get a clear idea of where you're at financially and what you can actually afford to settle or to pay. Awesome. Let's see. We've got a question from Mary. It says, I'm being sued by Cavalry. The credit card agreement says we'll pay for your share of the arbitration fee for an arbitration of claim of $75,000 or less if they are unrelated to debt collection. Otherwise, arbitration fees will be allocated according to the applicable AAA rules. What does this mean? Yeah, Sibley, I don't know if you have any thoughts on that. I feel like it's kind of getting into the legal advice realm. But Sibley, do you have any thoughts on that?
Again, not legal advice, right? So don't hold me to it. But I mean, just from what Hannah read, it sounds that as long as it's not related to debt collections, the arbitration cost will be covered. And if this is regarding debt, which most likely it is just due to the webinar topic, sounds like it won't be covered. That's just what I took of it from reading it. So I would assume that you should just assume you're going to be paying for those arbitration costs.
Okay. To give a little more context too, Mary also said that the debt is $17,000 from 2 years ago. She says, I'm on Social Security. I know that they can't take that, but I'm worried that they can put a lien on my house. Do you have any thoughts on that, Sibley?
In general, just generally speaking, if someone still chooses, if a judgment is granted and if they choose to, they, from my understanding, they could still put a lien. They may choose not to. They may choose that they'd rather not. It's really, again, communication, right? How are they going to know that's your situation if you don't communicate with them and see if something can be reached? But, you know, at least they won't know that that's your situation. But yeah, I'm not sure if that answers that question.
Yeah, it sounds like, Mary, you might want to look into some like legal aid in your area, or consult with an attorney to get more information on this. Just, I would say also be very careful if you're trying to decide if you want to file a motion to compel arbitration and go that route, because you could be in charge of the fees. It seems like maybe according to your arbitration clause you wouldn't be, but just be really careful before you take any of those steps. Next question is from Javier. It says, Apple Federal Credit Union is suing me. Should I file a motion for private arbitration?
I have no idea. I don't know what the benefits of it would be versus not doing it. I would suggest the same thing. Maybe seek like local counsel that might be able to better direct that, because I really wouldn't know the benefits of doing it.
Yeah, I mean, I can speak to that a little bit. I think the benefit of a motion to compel arbitration is just that it kind of kicks the case outside of the court system and puts it into a private arbitration setting where you've got one person that kind of helps mediate the conversation and try to come to an agreement between the two parties. An arbitration, filing a motion to compel arbitration can help you if you're not going to be in charge of the arbitration fees, but beware that those fees can be very costly, and so you don't want to file a motion to compel arbitration if you're in charge of paying for it, probably. But also, I would also just want to emphasize that, you know, if you have the means to set up a payment plan and try to settle the debt, I think that is the ideal outcome in these types of cases, especially if it's like a credit card debt or a personal loan. Like, creditors will work with you. You can settle the debt, and you can avoid going to court altogether. You can avoid arbitration as well. So just keep that in mind. Next question is, I went to court against Midland Funding last fall and won. Last week, I received a notice to appear in court for the same case. Can I file a motion to dismiss?
That is a great question. Honestly, I would again advise to seek legal counsel on that, because I think there's a lot of factors that would go into it, like what the definition is of winning, was it dismissed, all of that information. So I would, again, with or without prejudice, dismissed with or without prejudice, if it even got dismissed. So I think that's definitely one that you want to consult with the legal counsel about, because that's going to be a lot of factors that play into it.
Yeah, if you already won the case, then there should have been like a dismissal filed into the case already, technically, or some sort of like document that states that the case was closed. So you can also bring that up probably. But yeah, like Sibley said, it probably depends on how your case was dismissed. If it was dismissed with or without prejudice, could affect whether or not they can bring it up in court again. I will drop a little resource from the Solo Suit blog on filing a motion to dismiss, and that might help you with your question and figure out how you can do that, or why it may or may not be a good move for you. So I just dropped that in the chat for you. Let's see. We've got a question from Bob. It says, how do I know if the original creditor is suing me or a debt collector? My lawsuit came up about 7 months after the bank stopped communicating with me.
It should tell you who the plaintiff is. So if the plaintiff is, ex-creditor, then you're getting sued by a law firm on their behalf.
Okay, so yeah, on your court documents, it should say exactly who is suing you. It'll say the plaintiff's name. And if you recognize that as the original creditor, like a bank, then it'll tell you right there. But if not, it may say like a collection agency, right?
Yeah, I mean, regardless, I don't think a collection agency can sue you for, because most collection agencies aren't the ones lending. So for the most part, they should always be on behalf of a creditor, from my understanding of it.
I think maybe if it's a debt buyer, they can sue, like LVNV funding or portfolio recovery associates, like we talked about earlier. And sorry, I kind of use those terms, debt collection agency, because they are debt collectors, but they're also debt buyers. So let's see. Next question is from Galactic DNA. It says, I'm going to trial against portfolio recovery associates in November. I'm not sure if I should request discovery or not.
I have no idea what discovery is. So I don't know how much help I'd be on that one. Again, I would check with an attorney in your area to see if they could advise on that, because I honestly have no idea what discovery even entails.
Yeah, I think we have a resource on our blog for discovery as well. I'll try to find that and drop it in the chat as well. Yes, we do. We have a blog post called What Happens During Discovery. This might answer your question, Galactic DNA. I just dropped it in the chat for you. According to my understanding, discovery is just a legal process that happens after the person who's being sued files their initial response. The case may go into discovery, which is when both parties can submit evidence and documentation that supports their side of the case. So it's just kind of like a preparation for maybe a hearing or a trial in the future. But yeah, that blog post should give you more information on it. Let's see. We've got another question here. Let's see, it says, should I respond to the summons and complaint?
I think you should do something, whether it's if you're going to file, if that's what you'd like to do, or reaching out to whoever filed the summons and complaint. But I do think you shouldn't just do nothing. So whether it's the call, set up an agreement, or if you do want to file an answer and or set up an agreement at the same time, you can do both. But I think what you shouldn't do is just do nothing. My advice would be to respond in some way, shape, or form.
Yeah, I think that's great advice, and I would totally echo it. I just dropped another chat or another link in the chat where you can draft and file an answer to your lawsuit if you've been sued. If you go to that link, you can also find a tool called Solo Settle on our website at solosuit.com. Solo Settle is a really great tool that can help you negotiate with debt collection agencies or debt collection law firms specifically to settle your debt for less outside of the court process. And it's a really great tool that's driven by technology to kind of optimize the process and take the stress and emotion out of it, because it helps you negotiate online instead of having to call or talk to someone directly, which can be kind of intimidating, I think, for a lot of people who are being sued. So yeah, check out Solo Settle. It may help you increase your chances of settling the debt. But like Sibley said, do something, act. The worst thing you can do is ignore it. So let's see. Got a couple other questions. And we are nearing the end. So just wanted to say we'll probably take like 3 more questions and then call it a night. This one's from Cheswick. It says, is it possible to file a motion to seal for my case? My case is all public on my state's website, and I don't want my bank and job info to become public if my case reaches wage garnishment.
That is a great question. I've never heard that question, and I've heard a lot. I honestly have no idea. I do know that, like you said, it is public because, suits are public record. So I don't know if there's a way to make it private. I would definitely reach out to an attorney about that, because that is a great point. But I've never heard of it. So maybe I'm wrong, but I have not heard of it.
Yeah, I think this is also getting in the realm of legal advice. You may want to consult an attorney just to see if there's ways to keep that information private. But typically, most court documents will redact personal information, so you may be protected there, based on my experience. Let's see. I'm gonna find one more, or I think we got two more questions. Time for two more questions. Okay, so this says, what are some of the consequences of not paying my debt? So Sibley, earlier you kind of mentioned a judgment, wage garnishment, and liens. Can you tell us more about what that might look like if someone doesn't pay and they lose their lawsuit?
Yeah, so generally, if it ever does get to that point, you could get garnished. Again, it's going to vary per state, right? So every state is a little different. Some states allow one or the other or both. And then certain states are going to vary how much can be taken out for however long. So certain states, for example, would let garnishment happen, a wage garnishment happen for about 60 days for 20% of your wages. And some states will let it go until paid in full, which could be a year, 2, 3 years, but at a lower amount or a higher amount. It's really going to depend on your state. Or they can, it could result in a bank levy. So a bank levy is where, they go in and go into your bank account and apply those funds to the debt. So those are it. And there's also liens. So for example, if you try to refinance or sell a house, that would pop up and you would most likely have to get that taken care of before or during closing. So it's just things like that will get brought up.
Yeah, definitely don't want to deal with any of those things, which again, I think we've reiterated this multiple times, but that's why being proactive and trying to pay off the debt or settle it can be a better option. And even if you have been sued, you still have the possibility to settle the debt. So just keep that in mind. All right, well, I think this is going to be our last question. Let me pull one up. All right, this one says, I am being sued by Bank of America for credit card debt. They have not served me yet. What can I do? They are not negotiating.
So on the legal advice, I can't say what to do on the legal advice, but I'm curious on the non-negotiating part, because for the most part, most will come to an agreement. So it may not be what exactly we are hoping, right? Sometimes we're hoping that they would take a certain amount that would be great for us, but not realistic for them. But if that sort of agreement hasn't been reached, then I would maybe try for any sort of repayment plan until you're on a better position. And then at that point, maybe try and offer something when you're in a better spot. But for the most part, creditors are very open to negotiating. And then on the it not served part yet, I would definitely talk to an attorney and see what possibilities are available to you at that point since it hasn't been served.
Yeah, and I would also just say, there are ways that you can get, I think, financial institutions like this to negotiate with you. One of them being like paint a picture of where you're at financially. Make sure that they're aware of your situation. If you've experienced unexpected life events or financial hardship of any sort, like tell them that, and they may ask you to send proof. Share that with them, because if you do, the chances of them negotiating are probably better. So yeah, just be forthcoming again. And then lastly, I would just say, again, we have a tool at solosuit.com called Solo Settle. It's a tech-driven approach to debt settlement. It's a platform where you can go, if you've been sued for debt, and send in an offer to settle your debt to the collection law firm that is suing you. And you can start negotiations that way. And it's a really great way to not only negotiate, but to resolve your debt in the end. And with that, you'll get support from Solo Suit, you'll get legal resources that would help you along the journey. So yeah, and Sibley, do you want to share any other information about where people can find you to, contact you about your financial consulting services and whatnot?
Yeah, I have a LinkedIn, which is just Sibley Ortiz. I have a pretty unique name, so luckily there's no other Sibleys that I'm aware of. So definitely feel free to that. And then, just I feel like I'm gonna sound like a broken record, but I think most people, just piece of advice is most people have this, you know, notion in their mind of how they see collectors. But the times have really changed over the last decade or two, and so it's completely different than what it was before. I've heard horror stories of in the past, like years ago, but nowadays it's very much about customer service and finding just a mutual agreement with everybody. So, I know some people are, they get scared or anxiety to give a call, but I would definitely encourage it and just see for yourselves that it's a completely different time than it was years ago. And most people really do just want to help out and listen to you and come to an agreement.
Awesome. Yeah. Well, thank you so much. I dropped a link to Sibley's LinkedIn on the chat. So if anyone wants to go and ask more questions, you can find her there. And thank you so much, Sibley, for joining. Just know, everyone watching, that if you've been sued, you have options, you have resources. Debt collectors will work with you, and SoloSuit can help you along the journey. So check us out at solosuit.com. You can also send us an email at support@solosuit.com, and we can answer your other questions there and maybe help you along the journey further. So thanks again for watching, everyone. Tune in next week on Wednesday. We have another weekly webinar. And again, thank you so much, Sibley, for joining and answering your questions and sharing your experiences.
Of course. Hope everybody has a good evening.
Thank you. See y'all.